Good morning, everyone. Kautilya Arthashastra also refers to Shulka. You must be thinking which shlok I am saying. No, it's not a shlok. It is related to our today's topic, that is type of duties under custom law. Kautilya is also another name for Chanakya. I hope you all know who Chanakya was. Kautilya Arthashastra, which is also known as Shulka, that is custom duty, consists of import duty and export duty to be collected at the city gate on goods coming in and going out. Now, if I have to charge custom duty, I must know how many types of duties can be levied on different goods in different states. When I say different states, it doesn't mean the states in a country. Different state means which form of goods are coming, which type of goods are coming, from where they are coming, and what condition these goods are coming from another country to India. There are learning objectives from this chapter. Please go through them, pause the video, then we will move ahead. We will learn many type of custom duties, but out of this, the most important, which the duties which are charged on mostly many of the goods, or I will say most of the goods, is the basic custom duty, integrated tax. Yes, this is that GST integrated tax on goods, and social welfare surcharge on importation. Is it mandatory that if goods are coming to India, duty will be charged definitely on those goods? In general, yes, answer is yes. But our central government has the power to impose the emergency duty also and discontinue the duty in any state if government feels so. Like the era of devastation going on due to COVID, government has decided that government may abolish import duty on ventilator masks and many another products. A proposal to do away with custom duty and IGST on around 15 products category is being considered by the Revenue Department, officials told. Apart from the devices and other products needed by the medical staff, some raw material even, with the help of which we will be able to make masks and garments and accessories, are also in the wish list that has been moved by the Commerce Department so that no duty will be charged. Let's now move to the first and the foremost uh, type of custom duty, that is basic custom duty. Basic custom duty, it is levied under section 12 of Custom Act 1962. It is levied on import and export of the goods, calculated as a percentage of assessable value. What is assessable value? We will learn in the chapter of valuation, but calculate as a percentage of assessable value. If my assessable value is 1 lakh, duty is 10%. 1 lakh multiplied by 10% is my basic custom duty. Now, what is the rate of basic custom duty? Rate of duty is specified in Schedule 1 and Schedule 2, whereas Schedule 1 is for import duty, Schedule 2 is for export duty. General rate varies from 5% to 40%, and this is called standard rate of duty. Is there any further type of basic custom duty? In short, basic custom duty is also called as BCD, right? Yes, there are two types. First is standard rate of duty. We have just seen the standard rate of duty is 5% to 40%. For examination purpose, you will be told how much is the basic custom duty. For the practical purpose, government has a list in the schedule 1 what is the rate of duty on a particular product. Now, but what is preferential rate of duty? Government fix some preferential areas, and if the goods are being imported from these areas, the preferential rate of duty, which is lesser than the standard duty, will be applied on those goods. But is it compulsory? Anyone who claim that I want to claim preferential rate of duty and government will allow it? No, it is not that. There are some conditions. If these conditions are fulfilled, the government will allow. The most important one is at the time of importation, importer should make a specific claim of the preferential duty that he want to claim this preferential duty. He should also claim that the goods are produced or manufactured in such preferential areas as notified by the government. The area should be notified under section 4 subsection 3 of the custom tariff act to be the preferential area. The origin of the goods should be determined in accordance with the rule as under the custom tariff act. The note is, if importer fails to discharge the above duties, the goods shall be liable to the standard rate of duty, which might be higher in that particular case. Now, the next type of custom duty is integrated tax of the custom tariff act. Integrated tax under section 3 subsection 7 of custom tariff act, any article which is imported to India is liable to integrated tax. So till now we learned any things which is imported to India, two duties definitely will be charged. One is basic custom duty, one is integrated tax. Now what is the rate? The maximum as prescribed under the IGST Act is the 40%. What is the formula? IGST on import, it will be charged on assessable value plus basic custom duty, which we have learned in the previous slide, plus SWS. This is the social welfare surcharge, newly surcharged instead of education and secondary higher education cess. This surcharge is now leviable. Any sum chargeable on the goods under any law for the time being in force, that is safeguard duty, anti-dumping duty, CVD is countervailing duty, etc. So any duty, all sum of this on this value, integrated tax will be charged. Now the third type of custom duty is goods and service tax compensation cess. Unlike BCD and integrated tax, goods and service compensation cess is not charged on all the goods. It will be charged on the goods notified by the central government. As for now, they are charged on mostly the luxury and the sin products like pan masala, tobacco, etc. What is the formula for compensation cess? It is almost similar like integrated cess, assessable value, basic custom duty, SWS, social welfare surcharge, any sum chargeable on the goods under any law for the time being force, that is safeguard duty, anti-dumping duty, CVD, etc. But to clear the confusion, government said one point very clearly: while calculating integrated tax, goods and compensation cess will not be added, and same way while calculating goods and service compensation cess, integrated tax will not be added. Point which merit considered: following taxes would not be included while computing their assessable value for computation of integrated tax or GST compensation cess. Next type of duty is, if being an importer you imported the goods to India and you kept the goods in warehouse without paying the duty. In the warehouse only you sold the goods to someone else. Now before the goods being removed from warehouse, what will be the value? The value will be calculated as per the value determined under the act or the transaction value of such goods which is paid by the seller to you, is whichever is higher will be calculated. Let's say goods are of 100 rupees, right? You sold it for 120 to the seller. The transaction value will be called as 120. Or under the act, if assessable officer thinks the value of goods is 125, in that case value will be 125. In case of partial goods sold, you have goods worth rupees 100 but you sold goods worth rupees 50. In proportionate, the value will be calculated on the basis of this, and if the transaction value or the value under the act, whichever is higher, will be taken as the value of the goods. The next type of duty is under the heading additional duty of customs under section 3 of Custom Acts. There are three subtype of duties under additional duty. First duty is additional duty under section 3 subsection 1. Before the launch of GST, these duties under the additional duty were very much leviable on most of the products, but due to the introduction of GST, these duties are kept as a safe horizon. If required, if notified, then these duties will be charged. I will show you the government notification after a couple of slides. But what is additional duty? Any article which is imported to India is also leviable to duty equal to the excise duty for the time being leviable on like article if produced or manufactured in India. For your information, 99% of the product now excise duty is not leviable. Before the launch of GST, excise duty was leviable in India on any kind of goods which are manufactured or produced in India. So this duty is called as additional duty. For example, if on a product, dummy product, excise duty is charged at the rate 10% and same goods are imported into India, additional duty on these goods will be 10%. There is no confusion about that. Second additional duty is called as countervailing duty. Now the countervailing duty is charged to balance the excise duty leviable on the raw material, components or ingredients. In the last in the custom duty, in the additional duty, we are talking about the excise duty on the final product, whereas in the countervailing duty we are talking about excise duty on the raw material. Third and the last type of additional duty is levy of special additional duty under section 3 subsection 5 due to countervailing any loss of the sale tax, value added tax, local tax or any other tax if being enforced. All these taxes were fully operational before the launch of GST. After the launch of GST, they are now kept in side. If required, government can charge, but rate of duty should not exceed 4% on the value of imported articles specified in the notification. So I show you the government notification. Due to the introduction of GST, the applicable of additional duty of custom is very limited. So thus the additional duty on the custom will be levied only on the few products not leviable to GST. So you can read the further notification. Now the next type of duty is, now in custom we have two different types of duty. One is the revenue duty and one is the protective duty. Now revenue duty, basic custom duty, integrated tax, goods GST compensation says, all these are called as revenue duty. Those which are leviable for the purpose of raising custom revenue, right? They are called as revenue duties. Whereas protective duties are instead to be given protection to indigenous industries. If resort of prospective duties is not made, could be a glut of cheap imported articles in market, making the indigenous goods unattractive. Example is, let's say any product in India is available for 1000 rupees, but any country, for instance China make that goods in 20 rupees and sell it in India. What will happen with this? In India, industries will stop working because people will prefer to buy this 20 rupees goods, not to buy this 1000 rupees good. To save Indian industry, government has to apply protective duties. There are a handful of coupled protective duties which is charged by the government. We will see those duties in the coming slides. Further type of custom duties, we will do it in coming lecture. Let's revise the topic of custom with the help of some of the MCQs. I will show you the MCQ, pause the video and try to figure out the answer, then I will give you the answer. First question is, bill of entry is filed by, pause the video. Yes, the answer, I hope you have calculated it right. It is the importer. It is the importer who has to file the bill of entry. Next question is, goods imported into India ceases to be called as imported goods when? Pause the video and figure out the answer. Answer is D. Goods are cleared for home consumption after payment of duty. Next question is, shipping bill is filed by? Please pause the video and find out the answer for this from your notes. Yes, the answer is exported goods. Exported goods.